Hi, everyone. Welcome to today's webinar on the new CCPA requirements for privacy assessments, automated decision making, and cybersecurity audits. I'm Ben Warner. I lead product marketing here at Bravado AI. Yeah, we're really excited to have a privacy legal expert on this topic today with us, Jennifer. Um, actually, yeah, how do you say your last name? Is it
Brewer.
Brewer? And Bravado AI CEO, Vaibhav Antal. Yeah, so before we get started, as we always do, we will record this webinar and we will share the slides afterwards so everyone has that. And then, yeah, please do ask questions throughout the webinar. We'll be checking them throughout and trying to answer them during the presentation as well as after. So, and just to give a heads up, so we'll be starting off, yeah, focusing on these new requirements for CCPA, and then we will, the second half, discuss how Bravado AI has, automated solutions to help streamline these assessments and support privacy teams to scale these at their organizations. So yeah, with that, I will kick it over to Jennifer. Thank you.
Great. Thanks, Ben. So good morning, good afternoon, wherever you are. And we're going to dive right in. We have a lot to cover today. And I've tried to build these slides for you all so that they can be somewhat of a high-level playbook for you. So our agenda today is going over what the new obligations are and why they matter, the timeline, the threshold requirements, and then we'll dive into each of the three new areas, the cybersecurity audits, privacy risk assessments, and the ADMT obligations. We'll do a quick spin around how these line up with the GDPR and the EU AI Act governance requirements, and then a quick note on kind of, practical takeaways on how to get this implemented in your business. So without further ado, so the why are we talking about this today? On January 1st of this year, the new CCPA regulations went into effect and brought into scope the requirements for meeting obligations under CCPA for cybersecurity audits, privacy risk assessments, and ADMT. January 1 is when these many of these obligations started, but the timelines for when they are required or when enforcement will begin are staggered throughout. So we'll dive into those. And hopefully what you'll see is that these requirements echo familiar concepts that you have seen in other privacy regimes or data protection regimes like GDPR, but they have very specific, California-specific thresholds, rights, and then certification requirements. I think if you take two things away from today, the first is that the regulations are heavily prescriptive on documentation and what you need to be including in your documentation, and that they also basically establish an executive mandate for oversight. There are, of these three new obligations, two of them require certification under penalty of perjury to CalPrivacy. And so stakeholder engagement is key, but getting executive leadership engagement is a primary issue that I think many organizations haven't really dug into yet. So I wanted to start with the timeline because this is where I think it will help you level set on what your priorities need to be. The risk assessment obligations began on January 1. So basically, you don't have to have them completed this year, but you do have to ensure that products, services, business processes that meet the risk thresholds, they are in scope now for those risk assessment requirements. In 2027, the cybersecurity audit and ADMT obligations begin. In 2028, the first submissions to CalPrivacy for the risk assessment information begins, and then your audit certifications. And then the remaining deadlines will start phasing in 2029, 2030. So again, the bottom line is it's time to start building into your privacy and AI governance programs now these requirements so that you can meet the documentation and certification obligations that will be here before you know it. So what are the thresholds? For cybersecurity audits, if you're a business under CCPA and 50% or more of your revenue is from selling or sharing personal information, or if your business revenue threshold is met, so if you meet that requirement under CCPA as a business, plus you've got 250,000 consumers or households, or the sensitive personal information of 50,000 people. And that's it. That's the threshold. That means that you've met the requirements for the cybersecurity audits. For privacy risk assessments, there are these five thresholds. If you meet any one of them for that processing activity, then a privacy risk assessment is required. So sales or sharing of personal information, if you're processing sensitive personal information, automated decision making for significant decisions. And you'll see at the bottom there, I put a reminder of what a significant decision means. So it's the provision or denial of financial lending services, housing, education, enrollment, or opportunities, employment, or contracting opportunities, or compensation and healthcare services. Um, if you're inferring certain characteristics, there's two separate categories of inferences that are included as considered high risk that would trigger a privacy risk assessment, including the second on precise location data. And then if you're training models for the purpose of making significant decisions. And then finally, the ADMT thresholds are also met when you're using ADMT to make that significant decision. And so if you're using ADMT for significant decisions, you're going to have a couple different obligations here. There is an exception to some of the obligations for ADMT when there is human involvement in the decision. So we'll dive into that a little bit later. Um, so on that one, I think I'll have to dive in. There are exceptions, and I will say that these rules are very prescriptive, and so there are certain exceptions on like notice requirements and opt-out requirements when employment data is involved, but they wouldn't necessarily exempt you from the privacy risk assessments. So cybersecurity audits. In the regulations, they actually lay out the objective, and it's to basically implement into the law a written, information security program, a WISP, that many of us have heard about from other state laws, often separately under a law. CCPA brings this now into the law with these regulations. So these audits have to assess how your cybersecurity program is protecting personal information. So it's a little bit more narrow than maybe some other cybersecurity rules and regulations, because we're specifically talking about personal information under CCPA and not general corporate information from unauthorized access, destruction, use, modification, disclosure. So this should feel very familiar to many of us who have worked in the cybersecurity arena. Nothing really new here on the objective. But what the requirements include are, and again, this shouldn't be new for anybody who's been involved in, ISO or SOC 2 audits. You need a qualified independent professional using auditing standards. They do allow both internal and external professionals, so long as they meet the qualification and independence requirements. And if you're using an internal auditor, they must report directly to an executive manager or leader who is not responsible for cybersecurity. So the internal auditor can't sit under the security function and meet the independence requirement. As is pretty normal in cybersecurity audit, it must be evidence-based. So it can't be just assertions. The auditor must dive into the requirements and have evidence of compliance using that objective and independence that auditors use. But what is new is this executive oversight. The report itself, so which we're going to go into more detail on very shortly, it has to be provided to executive management who is responsible for the cybersecurity program. So here we've got two separate executives who have to be involved in your audit program in California. And they're the ones who are going to have to review it and sign off on it. And then finally, there is a 5-year retention period on all supporting documents after each audit's completion. So the audit scope, there's the assessment. So that's what the auditor is going to complete. There's an audit report that has to be provided to the executive leader. And then there's the certification requirement. So the assessment scope is what I said earlier. It's basically, looking at whether or not you've established and implemented and maintained your cybersecurity program. Um, and so there's three, top level requirements that the audit has to assess, and that's the written information security program. And then it has 18 controls that it's going to be looking at that should be, familiar to auditors. These are things like authentication, access management, encryption, things like that. And then how the business implements and enforces compliance. So that's, when you're looking at your cybersecurity policies and standards, is there an enforcement mechanism in there, that basically, a lot of policies will say something like, failure to, comply with this policy can, lead up to termination or something like that. One of the areas that the auditor is going to be looking at is whether or not your policies are just paper or whether they're actually used and enforced. The audit report then has 10 required components, and we're going to go into those more deeply on the next slide. And that's the report that has to be made available to the cybersecurity exec. And then finally, there will be a certification requirement that is submitted to CalPrivacy. It's not the submission of your audit report. That stays internal. However, they can request it. But what you submit to the CalPrivacy is different, and we'll get into that in just a minute. So this is the report that the auditor is going to create. Heavy text, sorry, on this slide, but I thought it might be helpful as you're kind of thinking through the requirements after this webinar to have kind of the top level categories of the report requirements. So they're going to look at, your systems, and what the criterion evidence and findings are there. They're going to look at effectiveness of controls. And as you look through this list, again, it's pretty familiar if you've been involved in any sort of cybersecurity audit. And the regulations do allow companies to submit a pre-existing cybersecurity audit as long as, or submit, retain and certify using that cybersecurity audit, as long as it's been prepared in a way that meets all of the Article 9 requirements. So when you're working with your security organizations and they're bringing in auditors to do the next, SOC or ISO audit report, you'll want to look and make sure that the requirements for California are embedded in there. So I've seen a lot of companies come up with like a common controls framework when they're doing these audits. So when you only have to, audit once, but you can reuse it across many different requirements. This is one of those areas where you'd want to ensure that the California requirements have been considered as part of that kind of common controls framework, if your organization is using that. And if your organization isn't using that and you're kind of doing these independent audits, I would look across. There are a number of companies, if you do a search for a common control framework, there are a number of examples out there, and they've made them kind of open source for companies to use. Let's see, it looks like we have a couple questions here. They don't have to have a particular certification, but they do have to use, I'm going to go back really quickly. They have to use accepted auditing procedures. So these are the ones by these organizations here are specifically called out in the regulations. And then let's see, there was one more down here. A broadening of any of these three thresholds. Not at the moment, but I think uh, that we're going to learn more, I think, once CalPrivacy starts seeing the certifications come through and determine whether or not there are areas where they need to provide more prescriptive requirements for organizations. And a New York Part 500 report. So on that, I'm not familiar with that report specifically. Um, but I think if you can compare, the report requirements against these 10 requirements, I think it should be a pretty easy way to map. So moving on the timeline. So for the cybersecurity audits, these are on a rolling timeline based on business revenue. So the largest businesses are up first. Um, and the audit period starts January 1, 2027. So cybersecurity audits are not yet in scope. They will become in scope January 1 of next year for any products that meet those or services, business processes that meet the thresholds that we described above. If your company has an annual gross revenue of 100 million or more. And there's I think a common misunderstanding of these revenue thresholds. So I just want to clarify, under CCPA, they're not looking at California revenue. They are looking at your annual gross revenue for that company. And so, if your company is global, if they're national, it's that total revenue. And that was you can find those in the statement of reasons from the original 2020 regulations. That's where the California AG answered on that question. So when you're looking at these thresholds, make sure you're not just looking at California. Um, so then the next band of audits that will be required is for businesses that are in that 50 to 100 million threshold. Your audit period begins January 1. And interestingly, they didn't go through December 31 of that year. They went to January 1, 2029, but then it also the next period starts January 1, 2029. So maybe that's an area where they'll clarify with that overlap. So the completed audit report is due internally, so that the report stays internal, but then the certification must be made to CalPrivacy by April 1 of that following year. So the year following the audit, if your audit was in 2027, by April 1, 2028, your certification needs to be made to CalPrivacy, and then same going forward. So what does the certification look like? It needs to include your business name, the point of contact, that you completed the cybersecurity audit and the time that was covered by that audit, and then the submitter's name, title, and date of certification. It also must include this attestation that's in orange below. And I highlighted the under penalty of perjury. So the person who is submitting has to be a member of the executive management team who is directly responsible for cybersecurity and has sufficient knowledge and authority to submit the certification. The only way to submit the certification is through the agency's website. But I just want to leave this attestation with you. I think, if you haven't had this conversation yet with your cybersecurity leader, this would be the first probably thing I'd want to sit down with them and say, here's this requirement. You're going to be directly responsible for submitting this attestation. What are the steps we need to take to prepare, depending on, when your organization's requirements begin based on those monetary thresholds. So
Uh,
that's
J-
it. Yeah, go ahead.
Sorry, Jen, on the audit itself, there are, I think, a bunch of questions that on the Q&A
Oh,
tab
perfect.
we can address. Yeah, I think back to
Yeah.
back. So,
So can you use an ISO 27001 in lieu? So you can use the 27001, you can use your SOC 2, but you do have to compare because they may not by themselves meet the California requirements. So what CalPrivacy is saying here through the regulations is those are sufficient to demonstrate compliance with the controls, so long as the audit report um, demonstrates that it's met, that the controls tested included all 18 that are in the regulations, and that the report that they submit meets all of the 10 requirements that are in the regulations. And so that's why I think at the very beginning of the engagement for when your auditor is coming in to do this audit, I think there's a timing aspect too. I know a lot of companies are already on a rolling audit review. This audit look back period is January 1 to January 1. And so, will the audit that you're doing for 27001 meet the timing requirements? Or do they start in, June, for example? If so, that won't work. So I think it's working with your cybersecurity organization to start lining those up if you can, or having them come back in and do like an addendum for CCPA and retesting those controls. So that's where I think a lot of the conversations should be starting now, to try to get all of these things that are already happening within the organization aligned with what California requires.
And a related question was around New York Part 500, but what I'm hearing from you is ISO or any other report or SOC 2, I mean, the answer is going to be the same. So, but if you want to still answer that and kind of like size that up, that would be great.
Yeah, that's exactly right. So I'm not, on all of these, I've not been involved in a New York 500 audit specifically, but most of the audits that I've been involved with all follow, they have very similar requirements, but they're not all the same. And so that's where you want to look at these requirements specifically against what the auditor is, against the controls of what that auditor is doing to see if you need to layer in anything specific to meet the California requirements.
Awesome. And then there are some questions around the auditor itself, and does the external auditor have to have a certification or some certification to be considered qualified?
So no, they don't, but they do need to use the auditing standards. So I'll go back to those really quickly here. So if you see here on the independents, they have to use the accepted auditing procedures and standards. So they don't specifically say that they have to be, a qualified auditor or an auditor, but they do have to meet the qualifications to be able to use these auditing procedures. So maybe indirectly they're saying that you need to be a qualified auditor, but that is not the specific text of CCPA. On the audit scope, the report, go back to the timing here. Where do I have that? There we go. Yeah, so the audit period, right. So the audit report is due April 1, not January 1. So the audit period is January 1 to January 1 of the next year, depending on where you fall for the next few years. The internal audit report needs to be provided and accepted by management internally by April 1, of that year. That same day, the audit certification it's not the audit report, it's a separate certification using this information needs to be submitted to CalPrivacy. So the due date for the completed report and certification is April 1. The look back period for that audit is January 1 to January 1.
There were a few more questions on the threshold. I think we can maybe club them. So there was one around, do you see a future broadening of any of the three thresholds? And then there was another question on, are these thresholds adjusted for inflation? So if you can touch on that, that would be great.
So at the moment, the only thresholds adjusted for inflation today are the thresholds of being a business. So they moved from 25,000 to, or sorry, 25 million to 26,625,000. And those update every 2 years. To my knowledge and understanding, the thresholds for the requirements here for the cybersecurity audits will not adjust, but I guess we'll see from CalPrivacy in 2027 if they decide to adjust those along with the business requirements, which those update for inflation every 2 years. And so is C-level personally accountable? I mean, they are to the extent that they're submitting this under penalty of perjury. So they are personally accountable under the perjury laws. Generally under CCPA, there isn't personal liability, it's corporate liability. But I think there's a lot of concern, given that the attestation is personal, that there could be some liability, direct liability for the individual here.
Awesome. And there are a few more questions. I think this is one question on the GLBA exceptions. Do they apply to ADMT audit risk assessment in general?
So the GLBA exception would only apply to the extent that the processing activity itself is subject to the GLBA exception. GLBA exception under CCPA is a data level exemption, not a entity level exemption. So just because you're processing GLBA data doesn't mean you're fully exempt from CCPA. You're just exempt to the extent that that processing is governed by GLBA. So you may still have additional requirements. So let's say your website and you've got online trackers that constitute a sale or sharing. That might be an area where, your organization could, sorry, that's more of the risk assessment. So on the side, but anyway, so I would treat the GLBA exemption the same way that you treat it today for your CCPA compliance. If all you're touching is GLBA covered data, then none of these requirements would apply. But if you have some of your business that isn't GLBA data that would be subject to CCPA, then these obligations would apply to that data.
Great. I think there's a broader on the audit side as well, was around like if you're a multinational organization, multiple laws, how to solve this overlapping problem. I know it's like goes beyond our today's webinar, but I think
Yeah,
it's an interesting, even in US, you have state laws. So I think there was a question around how do we anticipate other state laws reacting to it,
right.
and would that bring in more such requirements? So yeah.
So that's where I think the conversation needs to happen with your cybersecurity organization and understanding how they are looking at the various audit requirements that they have today and looking to see if you need some sort of common controls framework that can be used. Because what a common controls framework does, if you're not familiar with it, it like looks across the different auditing requirements for something like it looks at ISO, the SOC 2 requirements. It may look at GLBA and the security requirements there, even though it's not a standard and it's a law. But it's like, what are all the things that we're auditing for so that we can do one audit and meet a number of different audit certification requirements. This is adding CCPA to that list. So that to me is the most practical way I can think of to try to address the California requirements as part of your overall audit strategy. Otherwise, to bring in auditors to do, this certification, compliance with this law, HIPAA, it becomes too unwieldy. So I would do a search if you haven't already on common control frameworks. I believe Microsoft has one. I know Adobe has one that they've open sourced and made available. I don't know that they've inserted these requirements yet, but it's if you've got the general framework, then you can kind of take a look at it and see if it is close enough.
Yeah, you're absolutely right. There's the standard common framework, common control framework, which is pretty accepted. So I think largely what I'm hearing is like you need to align with the cybersecurity folks to add this there, and then it can scale as more state laws or more geography, country-based laws come in, and we just follow the same
Exactly.
approach. That makes sense.
Yeah.
I think there are two last questions on the audit, and we can move to the next section, Jennifer, which is the risk assessment. We definitely want to cover that, but we love all these questions that are coming up. So if there are more, please feel free to add. I think there
Perfect.
was a question around, there's one question around are audit firms becoming familiar with CCPA standard? I think you kind of touched that it's more of a conversation with the internal security team as well. And then I think they're testing the same controls more or less. So I think you kind of answered that. There's one more question around should companies wait until 2028 to bring in auditor if the audit period is 1/1 to 12/31, or should the auditor be engaged sooner to do an initial assessment and give the business time to remediate findings?
So I'm a big fan of gap assessments, and I would treat those a little bit differently than the assessment that's required here. And I would recommend if you're going to do a gap assessment that that is done under privilege, that you bring in your, internal, external attorneys. You can use the third-party firms, you can use your own internal audit, but to go through the requirements that California has and identify where you might have gaps that an auditor is going to find. So you can get those hopefully identified and scheduled and remediated ahead of you bringing in the auditor who's actually going to do the audit report for CCPA purposes.
Perfect. Thank you.
Yeah.
And I think you might cover this ahead in the next section. And I know the risk assessment questions are coming up. So, but there's one question that's been there for a while. It's around for significant decisions. Is basic employment information carved out? Example, managing employee benefits, managing employee salaries, etc.
So there are certain carve outs for certain specific activities, but I would say to get to that level of detail, I would have to look at it. I wouldn't want to answer yes or no, because I think a lot of it's very dependent on what the actual activity is doing. So on that one, I would say let's hold off on answering that one because I think what I'll have to do is like dive into the deeper requirements of CCPA for employment. And shameless plug, I did actually draft an employment specific blog post on our website. So you're welcome to take a look at that too, and that might answer your question.
Perfect. Thanks. Let's go to the risk assessment. And again, like as you get the questions, feel free to add them. I know we'll answer them as we go through the rest of the
Perfect.
webinar.
And I'm conscious of time, so if you let me know if you need me to race through anything so we can get to your,
No,
your okay.
I mean, like we want to make it useful for everyone who's joined. So it seems
Perfect.
people have a lot of questions. So I would say like take your time and we can manage our part in whatever time is left.
Perfect. Okay. So on this one, the risk assessment objective, similar to the cybersecurity audits, there's an actual objective in the regulations and restricting or prohibiting the processing of personal information if the risk to the privacy of consumer outweighs the benefits. And I would say on this one, CCPA has already identified the risks that they believe would outweigh the benefits to the consumer, the business, or other stakeholders or the public. So those five thresholds that we talked about earlier are what triggers the risk assessment requirements. If you are doing those activities, then you are in scope. And then from there to the question that we had, whether or not there are some exceptions, there are limited exceptions to the risk assessment, but they are very limited. So I would definitely take a look at what you're doing and making sure that you fall into those. On the timing, these risk assessments started, the requirements kicked in January 1. So if you're doing any of those activities that we talked about at the beginning of this presentation, you're already in scope for the risk assessment. And it's required this year. So the timing is now. You are required to conduct and document that risk assessment before initiating your processing activity. And they must be updated at least once every 3 years or within 5 days of 45 days of a material change. So I think that's really important because this is an ongoing requirement that your teams will need to be aware of and trying to understand how that fits into your current DPIA or privacy risk assessment workflows today. You can use a single risk assessment for a comparable set of activities. So if you, and this is very similar to the way that the GDPR is set up for DPIA. So if you don't have to do a DPIA for every product, if you have use cases or processing activities that are very similar across products, you can do one DPIA. This is the same. So if you've got, like a sailor sharing on the website across, several websites, that can be one risk assessment. As long as that risk assessment that you've done previously, and you can also use, the DPIA assessment process. You can use your existing risk assessment processes and documentation, so long, again, like the cybersecurity requirements, as the California requirements are embedded into those documents. So you're going to want to take a look at your existing risk assessments, whether that's a DPIA, privacy risk assessment, whatever it is that you're using to assess processing activities within the organization. You're going to want to look at those and make sure that the thresholds now aren't just EU focused, but they're including these very specific activities under CCPA, and that they meet the obligations under the risk assessment requirements. Similar to the cybersecurity audits, you are going to require stakeholders to help, so that teams that are involved in any of those threshold activities understand that they need to be engaged and part of this risk assessment process. And then the retention period, similar to the cybersecurity audits, is 5 years. Yeah, on the examples, there are some helpful ones in the regulations, but this would be, on the digital trackers. So ad tech, if you're using trackers on your website for targeted advertising, in most cases, I won't say in all cases, but I haven't found one yet where you're using targeted advertising cookies that isn't a sale or sharing. So I think of sharing as a subset of a sale. Sharing is the cross-contextual behavioral advertising use case. That's considered a sale under CCPA. And so, if you're using targeted advertising cookies, if you're using trackers in your mobile devices that are going to be used for targeted advertising, you've triggered the risk assessment requirements under CCPA. If you're collecting and using sensitive personal information, so biometrics, geolocation data, health data, any of those things, those are going to trigger your requirements. Workplace scoring is an area where you will trigger the risk assessment requirements. The recruiting tools that are out there can trigger risk assessments. So really taking a look at those, the obligations or the thresholds are very detailed. So I would take a look at that and start, jotting down like where are we doing things that could trigger this in our business, and start reaching out to those stakeholders to compare, what they're actually doing with the thresholds. So I did say it, but I'll say it again, retention, 5 years. So you're going to want to make sure that if you've got retention and deletion policies in place, the timing is a little bit different from other California retention requirements. So making sure that these are mapped and stored in a place that meet those retention requirements. Similar to the cybersecurity reports, I've got a very text-heavy slide here, just so you have the top line requirements of what needs to be in that risk assessment. So you need to have the business purpose. Business purpose under CCPA is very specifically defined. So if you're not familiar with what's considered a business purpose, I would go back to the definition and the regulations, because they are explicit as to what is a business purpose. And you'll want to make sure, similar to your DPIA that you do for GDPR, that you're explicit about, what are we doing this processing activity for? The categories of personal information, your operational elements. I'll let you guys read the slide. I won't go in too deeply given the time that we have. But I will say, we've got safeguards, processing status, and the participants, like who are the individuals, with the exception of counsel providing legal advice, who provided the information that has to be documented, and who reviewed and approved, along with their position information. And then the executive leader is going to have to ultimately review and approve the assessment. So the timeline on these activities that are in scope are right now. So to the extent you have activities that started January 1 of this year, they will need a risk assessment. But CCPA, I think because they realized how late they got the regulations to us, it was in November of last year, that we actually had time to read them, and then they began enforce on January 1 of this year. So you have until the end of next year to finish your risk assessments for activities that started this year. After, so January 1, they have to be initiated. So once you had a project starting this year, you still have to meet that requirement that you're initiating before you're launching that processing activity. And again, on the timing, you have to review them at least every 3 years or within 45 days of a material change. For the CalPrivacy submissions, the 26 and 27 risk assessments that you've prepared, you will need to submit not the risk assessment, but the required information that confirms the completion of risk assessments. Those are due April 1, 2028. So just, I want that to be very clear because I've heard some confusion on this front. The risk assessment themselves are not to be submitted to CalPrivacy. They can if CalPrivacy asks for them later, but what you're submitting to CalPrivacy is a similar attestation, and I will show that to you next, to the cybersecurity audits. So same submission scope, it's name, contact, the number of risk assessments conducted or updated per threshold activity, whether the assessment involved personal information or sensitive PI categories, and those are the defined categories under CCPA. And the submitter must be an executive management team member. Very similar wording to what we saw in the cybersecurity requirements. And the attestation is almost identical, just a different section is being attested to here. But again, under penalty of perjury. Did I say a chief executive? It needs to be a member of your executive management team. So not all, like, for example, if it's your chief privacy officer, as long as the chief privacy officer is a member of the executive management team, they can be the one who submits this. But it has to be an executive manager. So if your head of privacy is reporting to the chief compliance officer, then it may be the chief compliance officer who needs to submit. And yeah, so hopefully that answered the question. So it depends on whether or not the chief privacy officer is on the executive management team. So are they C-suite? That's who has to submit these reports. All right, and I'm going to dive quickly into automated decision-making tools. So again, it relies on the threshold of whether or not the automated decision-making tool is being used to make a significant decision. And I've added that definition back here again, just for a reminder. If you are, then it requires 3 things. It requires a pre-use notice. It requires an opt-out. There are exceptions if you offer an appeal process or you're using human review. So those can be exceptions to the opt-out, but by default, an opt-out is required. And then it allows individuals a right of access. And that is access to an explanation on the input, output, and logic related to the ADMT. On the pre-use notice requirements, they can be via a link. So if you've already got a notice that you're making, it can be just noting that we're using ADMT and you can learn more. That's fine, as long as wherever they're being directed to is easy to see, access, and it contains all of the information that's here in front of you. So it has to include the specific purpose, the consumer right description, that very similar to the other CCPA rights, that there's no retaliation. And then there's details about how the ADMT works. You don't need to include trade secret information or, anything that's going to prevent your ability to detect or prevent fraud, illegal activity, and those types of things. But it does need to be enough that the individual understands how the ADMT is making a significant decision about them. So on the exceptions, you have to provide an opt-out of the use of ADMT unless, like I mentioned earlier, you have an appeal process that has to be to a human reviewer who has authority to overturn the decision. I would dive into that requirement because it's very detailed as to what that human review process looks like and how much authority that they have to make that decision to overturn the ADMT decision. There's a lot of language in here, and I've really up-leveled and simplified it here just so you know that it exists. But I would get deep into the details if that's an area that you want to try to explore to accept the opt-out. The There is an opt-out exception if you're using automated decision-making for admission, acceptance, or hiring. So in the education area, whether to admit or accept, and then in the hiring area, if you're solely using for the ability to perform and the ADMT does not discriminate. So you'd have to be able to demonstrate that it does not discriminate. Then you do not have to offer an opt-out from the ADMT, but it's very limited. So the ability to perform or determine whether to hire. If you're using ADMT to make other decisions in that hiring or education process, it will be subject to the obligations here. And then the opt-out exception for allocation or assignment of work and compensation, so long as it's the information solely used for those processes. Where I see a lot of organizations running into issues with this exception is that a lot of times those same data points that we're using for allocation or assignment of work and compensation make very useful performance management tools. And so if you're using for a different purpose other than these two, you could be subject to the opt-out. So the opt-out methods should look very familiar to our other opt-out methods under CCPA, including the opt-out from sale or sharing. It has to be two or more methods, execute minimal steps. You cannot require verification or more information than necessary to process the opt-out, and an authorized agent can submit the request. You have to provide a means for the consumer to verify the opt-out was processed. This is also a new requirement under the regulations for opt-outs from sale and sharing, so that it shouldn't be a new requirement to many of you, but I wanted to call that out because it didn't get as much press or attention when the new regs went into place. And similarly, you must process within 15 days. If the opt-out is provided at the time the data is being sent to you, it should be immediately processed. If it's on data that you've previously collected, you have the 15 days. And then I think this is from a practical implementation perspective, especially where I see these tools being used. You have to wait 12 months before re-asking a consumer who opted out to reconsent to the use of ADMT. So I work a lot in the employment space. I don't know how this is going to work in practice for applicants to jobs who may reapply, over the course of a year for different jobs. How do you recognize that individual who's applying and their resume may be scanned and preventing them from being, up-leveled to a place of review. So anyway, I think there's some interesting practical implementation issues to be sorted out here where you trigger these requirements. And then finally, responding to access requests, exactly like, the existing language for other individual rights requests under CCPA, it has to be plain language about the tool's specific purpose. It should follow along with the notice that you gave, but then the logic, the outcome, and then again, the same prohibition on retaliation. And then the response obligations. So the submission methods need to be easy to use and free of dark patterns, which follows along with the rest of the regulations requirements. On the access requests, on opt-outs, no verification. On access responses, there are verification requirements. So again, setting these up from a very practical standpoint could be tricky, but I would look at how you're doing it today with your do not sell opt-outs and your individual rights requests for access correction deletion. The access here should fall under the same procedures you use for those access correction deletion requests. And the opt-out from ADMT should follow the same procedures as your do not sell. Similar to the other CCPA requirements, you can't require a portal, but you can use one if you have one. And then the response requirements. There is this aggregated response rule when you use ADMT. ADMT is used more than 4 times with a consumer, you can provide an aggregate level response. And there's a lot of detail in the regulations, but I did want to call that out because that might be a way to help with that earlier use case that I just brought up in the applicant context. On the timeline, so significant decisions made before January 1, 2027 must comply with these requirements no later than January 1, 2027. What does that mean? If you're making significant decisions using ADMT today, you're going to need to be in compliance with those decisions between January 1, 2026 and January 1, 2027 by January 1. So we don't have the April extension for ADMT compliance requirements. So starting January 1, 2027, anything that you've got now making a significant decision will need to comply with the pre-use notice requirements, the opt-out requirements, and the access requirements. And then beginning January 1, 2027, everything's in scope. So if you launch something on January 1, it will need to comply starting that day with the obligations. So I'm going to just leave this with you. When you ask for the slides, you can kind of dive in here and you can see where these requirements align, diverge, and hopefully some practical information. But I'm going to go right through these, just these so I can give you some time. And then here's an implementation roadmap. Shouldn't look much different from other things. Know what you've got. So mapping use cases, inventorying workflows. You need a triage. We're already in May of 2026. So if you're not doing risk assessments yet or don't even know what you're doing risk assessments on, now's the time to start meeting with your stakeholders and starting to map out, what are the key areas of the business that have the most risk for these requirements. And then, updating retention operations. And then I'll just hit it again, regulatory submission. If you haven't worked yet with your executive management team on who's going to be responsible for these submissions, I think that's among the first phone calls I'd be making after today. So any other questions here?
Thank you. So I know we have 8 minutes left. Folks, feel free to add those questions. I'm going to hope to present something in 4 minutes. So let's see
Sorry,
if I
B.
can. No, not at all.
Oh, this is great. This is why we did the webinar. It was, Jennifer, you were the star of the show, so this has been great.
So yeah, let's see how quickly I can pull it up. So yeah, folks, feel free to put the questions in the Q&A. As I said, I'll take a couple of minutes to talk about on the solution side, how you can operationalize it. So we did talk a lot, but what we'll focus on is on the risk assessment. I'll take 2 use cases live. What Privado does it, we kind of modernize privacy operations, privacy compliance using agents, different scanners. As you look into operationalizing the privacy risk assessment for CCPA or merging it with your current risk assessment process, kind of like what the implementation also was talking about, it will follow something very similar. Your business will propose something new, which will be a request or an intake. It will go through a triage, your first level of assessment, and then a deeper assessment as well, right? So it follows the same typical process. The pain points which are going to happen will be the same, which is, it is going to be dependent on what the stakeholders tell you about the use case or the processing activity. It will lead to some friction in terms of how much hours your business will have to spend on the assessments as well. And then most likely it will lead to 2 things kind of very consistent with the regular assessment process we've seen. One is, it will take time for you to fill. So of course, as it was suggested, start early, but especially because a lot of time is going to go into these back and forth of chasing the team to fill the questionnaire itself. And then, of course, this also means you might have some delayed projects. On the other hand, what I feel another big risk is while you're not submitting the risk assessment itself, but if the risk assessment itself is inaccurate and is incomplete, that also adds some risk. And maybe Jennifer can add more into that towards once I finish my stuff. Is like, what's a inaccurate risk assessment? Is there a consequence of that? But I do feel CCPA, just the submission requirement itself raises the bar because now you're at least, opening up your use cases. And again, some of that could be auditable. Let's say if you do a press release externally and, you do a submission and that press release basically means that, that should have been covered, but it's not in your risk assessment submission, that could be something that could be flagged. Simple things always happens. Um, so, so real quick on the solution, like we basically take care of this entire process. You can use our solution from intake, triaging, doing the actual assessment, doing the risk assessment as well. Since we don't have a lot of time, I'm going to jump right into the assessment generation part on if there is a new use case, how you can use Privado, and then hand it back for Q&A. So I picked, again, I use Claude, so using AI to make up some fake cases for an e-commerce company. So there are two things which I picked up. One is a personalization engine. So the product team is coming up with a new functionality where they want to make sure on the same homepage, they can give better recommendation on new products they can buy. And, this is like what a product person will build. If you have engineers in your team, product teams, they will build documents like this to build new functionalities or new features. So this is one example where they're proposing to use browser history, use them to create personalized homepage. There's another one where what they're doing is we want to improve reordering. So we'll just show what they ordered and just allow them to reorder. So two different use cases, which are going into our risk assessment pipeline. And then let's look at what it looks like. So in Privado, you can run the risk assessment manually as well, or you can use, as I said, our agent. In this case, what we did was we uploaded the same document I showed you, this PRD or product requirement document, and then we went through the risk assessment process. It picked up, put a name of that use case, gave a description on what we are doing. So it's a personalization layer, picked the purposes, picked the team who owns it, selected the category of users, selected the region, selected the data elements, the third parties who are going to receive the data. And then, of course, like from a accountability perspective, everything has proof and evidences. So you can always look at, hey, where does it state that we are going to share data with Meta or TikTok, things like that. And then the second main part, which I'll focus, is the actual triaging. So this is the threshold part. So the 9 criteria. Does this involve sale or share? Yes. The moment we have this as yes, basically pretty much we know this is going to be considered, but there are more. So it does involve sensitive personal information or SPI because it's precise location data. It doesn't qualify for employment exemption. It's not applicable. Does it use ADMT? It does, because there's some scoring which is happening, but it doesn't use it for significant decisions. Of course, you can overwrite any of them. The main thing is how do you get to triaging fast where okay, this qualifies for a full CPRA risk assessment, and then you can follow along. So there's a bunch of things. Again, since we don't have time, also want to point out these are the same. We map it to the same risk which are in the law. So unlawful discrimination, is there a use? Is there a risk? So we'll come up with those risks as well that you can then kind of start working with your team. So this was one example where the risk assessment does apply. This is the other one where we were just adding a reordering button. In this case, it doesn't qualify. So the threshold assessment, as we'll see, is like a no. Basically, doesn't have sale or share of data, doesn't involve SPI, doesn't have ADMT, doesn't use automated processing for extrapolating correct characteristics or consumer characteristics. There is no personal data used for ADMT. And then the answer is like, yeah, based on response, is this required? No. Or you can change it to yes if you still want to do that. So I know I covered a lot in a very short span of time. But yeah, the main what Privado can help you with is as you scale these assessments, especially if you're late or you have a lot of use cases, you can use us to just focus on maybe doing the first threshold assessment and then generating the full assessment, and then you can bring the executives as well around to make sure it is fit for submission later. With that, I will send it back for Q&A. Jennifer and teams, if you anyone who's on the webinar, if you have any more questions, feel free to add them and we'll try our best to answer them. Cool. Don't see any questions, but yeah, let's give everyone a few minutes. If they have any more, we'll answer those. Okay, I see one question. Okay, so thank you. All right, perfect. I think, Ben, then that's it. Then we are done with the webinar. Over to you.
Awesome. Thank you, Vaibhav. Thank you, Jennifer. It was an amazing webinar. Yeah, going deep on these new requirements that, yeah, I think are going to, change a lot of the ways that these privacy assessments are done. So, yeah, I know it's a little bit early, but it's also past the start time. So there's still time to get started on these things. Other CCPA topic we want to talk about. We have a webinar June 11th, diving deep on the latest CCPA enforcement against GM. It's nearly 5 times larger than the previous largest one, over $12 million. So we have Daniel Goldberg from Frankfurt Kernet. He will be diving deep on it, and we also were in the process of getting a privacy leader who can come and give their perspective. So please join us on June 11th for that webinar. I will put let's see, the links in the chat. Other than that, yeah, you'll see the slides for this webinar, the recording, and then more information about the next webinar in our email. So thanks again for attending, and we'll see you next time.
Thanks, everyone. Thanks, Jennifer.